I am just disappointed, and I will say it, that the senator of Nakuru is holding brief for criminals in a criminal case.
Order, Governor. Governor, order. You cannot make those kind of allegations on a senator sitting in the Senate. You know the rules. You've been the Speaker of a House. Can you withdraw those comments, Governor, that the senator of Nakuru is holding brief for criminals? That cannot be accepted.
But luckily she's here. She can say yes or no.
Order. I am the chair. Order. My duty is to enforce order. Governor, you will withdraw those comments that the senator of Nakuru is holding brief for criminals. When she called you a liar, I told her to withdraw. Please follow suit and withdraw so that we can proceed.
Okay, she's holding brief for the defendants. Is that better?
Governor, please just withdraw. I didn't ask you to paraphrase. I asked you to withdraw so that we can proceed. This is a house of order.
Okay.
I will not accept any member here or even you, Governor, being accused of illegalities. I will defend and protect you. I will defend and protect my senators. Please go on record.
If I can substantiate.
Please go. You want to substantiate?
By her own statements. She's holding brief for that instead of for the public land.
So it is your view that you want us to spend this session on substantiation of your allegations?
We can.
It is not a useful application of the time of the Senate.
It's not useful, but I was ready. Because you also said I'm saying that so we can close down the meeting. I can be here until 6, substantiating.
Governor,
it's okay, I will withdraw.
Fine. Now you can proceed.
For criminals, I will withdraw.
Now you can proceed.
Okay. So, Chair, maybe some of it may say, some senator may say I'm agitated or that we are bringing sideshows. It is not sideshows. It is just I feel very strongly that as a governor of Nakuru County, it is my duty to make sure that public land is not fraudulently taken by people and then come back and say because it's a hospital, we must let them continue. So yes, we have our county attorney has been instructed.
The rules of sub judice in the standing orders bar us from discussing matters that are substantively before the courts.
Yes.
The issue of ownership, the issue of legality of leases is part of the criminal proceedings in court.
Yes.
Let us not discuss them. Let me guide you that come back to order number 7, order number 6 and number 7 in the order that you have attached. That was a question asked by Senator Omogeni.
Yes.
Let's address that. At least that is safe ground. And, that will not make us go sub judice.
I agree, Chair. And in fact, at the beginning, if you recall, I had told you I actually should not be responding to this because it's sub judice.
No. What is before us is not sub judice. The order of the court is not sub judice unless you confirm that order number 6, unless you tell us how order number 6 and 7 were implemented. That was a question that was raised by Senator Omogeni.
But Chair, you can't also sit there and let some of these senators throw some allegations here regarding what I am not doing as far as health, and then when I respond, it's sub judice.
Governor, I request you to address yourself to order number 6 and order number 7.
Which is 6 and 7? Which one?
And if it is to help to refresh that this particular order, mention of compliance was to be done on 7th of October 2024.
Oh, okay, it's that one. Okay.
And that the High Court was to determine the dispute within the next 60 days. Perhaps order number 6 is not yours. Just tell us how order number 7 was dealt with. So was there a mention of compliance?
Yes, that's the one of the, with the attachments. So, Chair, that's the one we have responded and given you attached the attachments as I speak. And as a county, we have done what the court required us to do, which was form or participate in the formation of that joint committee. Our 2 members in the 5-member committee, who is the CEC for Health, she's still the CEC for Health, and the county secretary are still part of that membership. Now, as I stated, and I will just repeat it for the flow of this, that we have done our part, but the defendants feel that they cannot reopen the hospital jointly with the county, and they have been saying that they will go back to court for they will go back to court for that. So, Chair, that is where we are. However, I have instructed a couple of weeks ago my county attorney.
Governor, have you read order number 7?
Which
order number 7. So that we deal with that. I don't want us to stray.
Okay. Yeah, I'm responding as far as the order by the High Court. Isn't that the one?
Order number 7 required that mention of compliance be done on 7th of October.
Oh, okay.
Compliance with this order.
Okay.
That's what we are asking, because you have told us the stories about how the other party is not cooperating.
Yeah.
So can you just tell us whether that order has been addressed or it's before the courts? So that if it's before the courts, we leave it as sub judice.
I can quickly ask and we can return. I can come back to it. But I know we have gone to every hearing. There is no hearing that has been missed.
Was there a
so
mention?
I'm sure this was
a mention of compliance on 7th of October?
Can I ask the attorney, who is one of your senators?
Yeah, because that is critical. For us, we will not deal with other issues. We just want to know why this order cannot be enforced.
Point of order. Who is the attorney?
The attorney of record is Professor Ojienda, who is one of the senators. But I will ask him real quick.
Where is he?
Governor, is there anyone? Order members, is there anyone in your delegation who can give us? Yeah, because I thought you had someone from the legal.
He can.
It's a clear question. It was asked by a senior counsel, and I think it requires just a clear, direct answer. 69.
Thank you very much, Chair. The matter, I can confirm that on that particular date, it didn't come up for compliance, but it's coming up on 22nd of this month for the ruling of the applications.
Senior counsel?
You see, Wakili, compliance means that you have to tell the court whether order number 2 that required the hospital to be opened had been opened. So what we want to know is, when you went to court, did you tell the court you have complied, or what is on record? When you went back to court, what did you tell the court? Because the court wanted to know whether you had complied with order number 2 that said War Memorial Hospital shall be opened immediately. So what did you tell the court?
Thank you, Senator. On that day, the court did not say it. Yeah, it did not sit on that particular day. Yeah, but we got another date. And we are hoping that we can get the final ruling on 22nd of July to put this matter to rest.
So since October 2014, the court never sat again to know whether there was compliance of a court order?
On that particular issue, to check on compliance, I would need to confirm.
My God, you are letting down your governor terribly.
Yes.
Terribly.
Since 24, we've gotten 10 court orders to reopen that hospital.
So, honourable members, I thought we were going to get some substantive answer on that. Members, that is the situation. We shall be the judges.
That is why
the
good advocate, we should take it up with the membership, with the Law Society. And Governor, that explains why you had to look for Senator Professor Tom Ojienda. Yeah. Because if you are in House Council cannot answer something that says just compliance.
Can I add?
Okay, order members.
I wanted to add on something on Cherangei.
Okay, now
You've been calling for the RSK.
Yes.
Let it go into record. RSK demonstrated in the Nakuru, and before they reached the office of the governor, they were beaten with stones by police. It's good to go in record.
Okay. Senator Tabitha.
Very serious
Senator
matter.
Tabitha and Senator Cherarkei, we have the order before us, which has been adduced as evidence. Order members. We have the order before us, which has been adduced as evidence of progress made to reopen the hospital. It has been stated by the governor under oath that the hospital is not yet open because of non-cooperation of the other partners. But we have also seen clearly in the order that there was supposed to be a mention of compliance, which was not done. We will then have to sit down and interrogate where the problem is. Is it in the judiciary that did not bring up the matter for mention? Is it the county that sees no sense of urgency? Or is it the other party? We, as judges on this matter, we do not have to pronounce ourselves, but we have all the facts before us. We have all the records before us. Let us restrict ourselves to the issue of value for money. Let us restrict ourselves to the issues of public interest, and let's allow the courts to deal with the issues of ownership of land. But I think from where we sit, it sounds unconscionable that you will have a hospital that is fully equipped, that is shut down as a result of legal disputes. That is not prudence. That is not the definition of prudence as per the Constitution and as per the PFM Act. So, members, we can leave it at that. Let the citizens of Nakuru be the judge on who is at fault on this. Senator Charaki.
I thought the issue is about lease, but not ownership of the land. I thought that should come out.
Members, we benefited from the earlier brief. The question of lease and ownership is an active matter in court.
Okay.
So we leave that for the courts to determine. I think the matter that we can address is value for money and prudence in application of public resources. Now, members, can we make some progress?
Yeah, may I? Just one minute on that. Because I did say that I will ask the substantive attorney on the case. And I have the answer that actually they were in court yesterday. And we have closed our case. So we have completed our part. The issue of compliance is a substantial part of the trial. So even by discussing it so much, it's sub judice. And because the case has come to an end, and as you have heard, the ruling is on July 22nd, I think it would make sense to wait and see the outcome of the case then, because it's been a lot of litigations. There's actually a lot of cases pending based on this, but this is the main case. But just for the record, as I conclude, the same cases, the same issues happened in Machakos and Kakamega, where such hospitals were such people tried to fraudulently take these hospitals. So Nakuru is not unique, and we shall not give up on fighting for the rights of Nakuru people.
We shall give specific recommendations for Nakuru County, because that's the entity before us. Honorable members, I want us to move on to the other residual matters. We had come from the motor vehicle ownership to the land ownership, and we came to this matter of Nakuru War Memorial. Now, let's go back to the other issues of numbers. Auditor General, you had flagged unaccounted disbursements to another county fund. You had advised that the 1.96 billion queried there has now been accounted for?
Yes, Chair, that one has been accounted for, but we combined it with the question number 8. That's what's talking of lawfulness of retaining monies for the public facilities, non-compliance with the Finance Act.
Okay, so for avoidance of doubt, and for those who do not have the documents before us, the 1.96 billion were transferred to which entities?
Public health facilities.